Welcome to Popcorn Planet. I am Andy Signor. So happy to be here with It's Kim and Mr. Christopher Melcher as we discuss some breaking news in the Johnny Depp case. Yes, there was news today. We actually learned that there were lawyers were meeting today one more time. Now, I just took this for its face value, but Christopher's about to correct us. Apparently, this article said they were giving them one last chance to settle their case before the verdict is final. Apparently, the judge had allowed that to happen unless the two parties agreed to a settlement. Today was the day to finalize the verdict if there were no other issues, in which case the clock would start ticking on the appeal. And yes, turns out they did. They finalized the verdict is official. There was no injunction from JD's team. Judgment stands per the judge. Everyone signed, and that's it. Now the clock starts if Amber is willing to pay the full amount, which is the bond, plus 6% per year to appeal. So glad to have Christopher here. So Christopher, excuse me, what does this mean? Fill us in.
Well, the headline that unfortunately got repeated was incorrect. There was no settlement conference set for today, and we don't know of any attempts by either party to settle. What the hearing today was about was to enter what's called a judgment. So at the end of a case, after the jury has deliberated, issued its verdict, its decision, that has to be reduced down to a piece of paper that basically ends the case, which is called a judgment. And the judgment would say on Johnny's claim against Amber, she has been found to have defamed him and owes him $10.35 million. And on her claim against Johnny, related to Adam Waldman's statements, Johnny owes her $2 million. Signed the judge. That's all they were trying to do today, was to address the wording of that judgment. And it was also an opportunity for either side to file a motion for juror misconduct, motion for new trial. Neither side, as far as I could tell, has done that. So as of today, a final judgment has been entered, basically saying, here's the piece of paper, this court case is finished at the trial court level. Now, either party, and I suspect it will be both parties, will go to the Court of Appeal, which is a supervisory court, and say that we're unhappy about this judgment, that the verdict is incorrect for various reasons, and ask the appellate court to take a look at it. That process would take, I don't know in Virginia, but typically out in California, 2 years. Now, the question becomes, what happens to these orders for each other to pay money in that 2-year period? Well, the filing of an appeal does not stop the ability of the judgment creditor, the person who won, from enforcing it against the losing party. So the mere filing of an appeal doesn't stop any of that enforcement unless they post a bond. And if they post a bond in a sufficient amount, then they would be able to stop enforcement. So there are some additional issues to unpack here about what Johnny's going to need to do here. But that's basically what happened today. We got a final judgment entered. Next step is going to be an appeal, and I suspect by both sides. Your audio's off.
You're muted.
I was coughing. I forgot to put it back. What is the bond? Because a lot of people are speculating. Some are saying 400,000. Is it the amount? Do you know, Christopher? How do we deduce what the bond plus 6% actually is?
Sure. So again, there's some confusion because of Virginia apparently uses these terms for different purposes. Okay. So first of all, there's a right to appeal. So you don't have to have great grounds. You have the right in Virginia, as in probably every other state in the U.S., when you've lost a case, to go to the Court of Appeal, and it's a very narrow grounds to win, but to at least ask them to saying, take a look at this, okay? She absolutely has that right. She will have to post some filing fees, some nominal fees to exercise her right to have the appellate court take a look at it. She's not going to win her appeal, but she has the right to ask the appellate court to take a look at it, and she'll have to pay some nominal fees to do that. The bond is there to protect Johnny in the event that she wants this judgment stayed. So what that means is that while this appeal is going on for 2 years that Amber's going to file, Johnny would normally have the right to go after her assets and try and say, I want my $10.35 million, Amber, and go to her bank account. If she writes a book, go to the publisher, get those monies. If she does another movie, get those monies. And she is subject to that collection, even if she's filed an appeal. If Amber says, I don't want to be subject to that collection, I don't want him taking any of my money, then she has to post what's called a bond to secure the 10.35 million, to make sure that if Johnny is blocked from collecting the money from her during her appeal, that the money is going to be there at the end of the day when and if she loses the appeal.
Right.
So if she can absolutely file the appeal for a nominal sum, if she wants to block Johnny from collecting the 10.35 million during this 2-year appellate process, she needs to post a bond that's issued by like an insurance company that has the money to pay to cover $10.35 million plus 6% interest. So we're talking now, 10, 11, $12 million that an insurance company would pledge to pay Johnny if she loses her appeal for the right to stop collection. There's no way she's going to do that because she can't afford it, number one. She can file for bankruptcy and block him along there. Even if she doesn't have $10.3 million.
Well,
it's a worthless piece of paper.
But where she did have that money because she never paid it to the charities. So there is money floating around that Johnny could pursue, which is his money, right, that he paid her to pay the charities. I mean, doesn't that money mean something? I mean, couldn't they do an audit to figure out, well, like what you had this money that you pledged to charities that you said you need to put towards your court fees, but we do know your insurance company paid your lawyer fees. So where did that money go? Is there a way for Johnny to sort of figure that out?
Yeah. And I shouldn't say completely worthless. What I'm saying is there's no chance that he's going to collect $10.35 million because she's never had that money.
Right.
He paid her $7 million back in 2016 to 17, and she must have spent good chunks of that. She bought this house in the desert. So yes, he can do a judgment debtor exam on her, call her in under oath. What do you have? What did you do with your money? And go through and seeing like, where is your bank accounts? Where's your savings? Do you have money that's coming in from a movie deal or book deal? And try and ask those questions and collect it. It's very difficult, but I can guarantee you he's not collecting $10.3 million from her because she has never had that much money in her life, and she certainly doesn't have it now. But it's so he may collect some.
It's going to cost her, though, because if he or his team really wants to do that, they can continue to make that harder for her to sort of keep the books, and then she's got to pay somebody to follow through. Can she? Is there just a get out of jail free pass here? Can she apply for a bankruptcy? Like, I know we've discussed a little bit, but like, is there a fail safe for her to sort of be like, can't pay it, sorry, adios?
It's very easy. So she can file for bankruptcy in the U.S. And the moment she files her petition for bankruptcy, Johnny's blocked from attempting to collect this. There's actually a court order goes into effect. It's called an automatic stay, and there's very serious consequences for violating it. So the moment she files for bankruptcy, a stay goes into effect, and this will cost her very little money to get, and it'll absolutely block him from doing any collection efforts at all until the bankruptcy court, determines whether this is a dischargeable debt. So that would be one step. Johnny would come in and say, look, this conduct was intentionally harmful, and there is an exception in the bankruptcy code for a judgment that results from intentionally harmful conduct, and ask that she be blocked or precluded from getting bankruptcy protection. I doubt that the bankruptcy court would find that exception applies, because even though there was this finding that she made the statement with actual knowledge that her op-ed was false or reckless disregard for the truth, the bankruptcy court's role there is to protect people from collection of debts and to give them an opportunity to reorganize. So my guess is that the bankruptcy court would say no, or at least hold a big hearing on that and delay it. So that's what she's going to do. She's going to file an appeal. She's not going to post some bond because she couldn't afford the bond fee. Right. No insurance company's going to say, yeah, I'm going to pay $10 million when you have your loser appeal decided. without getting a gigantic amount of security, they're not going to be out that money. She'll never post a bond, never happening. She would file for a bankruptcy most likely, or possibly. That's the easiest way. It'll stay it. I doubt he's going to collect much money. The bigger issue for me is that Johnny lost, and in that claim relating to the Adam Waldman statement, and the jury found that Johnny owes Amber $2 million. And so I was thinking that was offset, meaning that we would take the $10.35 million that Amber owes Johnny minus the $2 million that he owes her, net $8.35 million owed to Johnny by Amber. Andrea Burkhardt has been looking into this and is thinking that there's probably no offset under Virginia law. If that's true, then Amber owes Johnny $10.35 million. She can do the appeal. She can do the bankruptcy like we just talked about. Johnny separately owes Amber $2 million. And unless he files an appeal and posts a bond, she can go against his bank account and just swoop out the $2 million. And there's no way he's going to allow himself to be subject to that. So what he needs to do is file the appeal, post a bond for $2 million, or he can just put up $2 million of his own cash and with a court clerk saying, fine, here's $2 million plus 6% interest for 2 years. Here's my security, Amber. In case I lose my appeal, you're going to get this money. And then hope during that 2-year appellate process that he can collect at least $2 million from her to offset the $2 million that he owes her, or that he can convince the appellate court that Adam Waldman was not factually speaking on his behalf, that the jury got that part wrong and reverse it. So, again, it's, we got to remember Johnny lost a little bit on this case too. So he does have some exposure. God,
that's so frustrating to think that he could then have to be on the hook to pay her and then she can just get away. He could pay her, and then she has $2 million in the bank, and Johnny can't fight to be like, yo, give me the money that I just paid her in the bank. That makes no sense.
I would hope that there's a process there in Virginia where he could say, hey, I'm going to, and Andrea Burkhardt had kind of alluded to this in lawyer speak, but basically saying, hey, Amber, I'm cutting you a check for $2 million for the money I owe, but I'm also immediately, as a judgment creditor, lobbing on to now your $2 million, Amber, and taking that to apply towards the $10.35 million that you owe me. I mean, this is why, we have lawyers. I mean, because you have to get creative. And so he'll find a way. Don't worry about Johnny. He's fine. I doubt Amber Heard's going to be rolling around with $2 million of his cash. He's got plenty of ways, like I just outlined, to avoid giving her this dough, but he does have to be strategic about it. And he obviously has counsel. They've already thought through these issues, no doubt, and have a plan in place.
Chill Chica just said, in Virginia, only punitive damages are dischargeable in bankruptcy. Law and Lumber covered that, and she covered it that she can't discharge it even in other states.
That's not true. So there's and I could pull up the code section
I believe
in
you.
the bankruptcy code.
You.
But it's again, it's you under the bankruptcy code, and I think it's like USC 523A6 or something like that. I could look at this to see if I'm right.
Amazing, he knows those numbers.
But it's the...
You challenging Mr. Melcher because he's about to drop some bombs on you.
Yeah. So it's 11 USC section 523. And so there's an exception in that code section to cases where, willful and malicious, it's A6. So a judgment that results from willful and malicious injury by the debtor is not dischargeable. So everyone's coming in and saying, well, there was actual malice. And I hate that term that they use in defamation cases, because malice does not mean for defamation, I hated you. Malice means that she made a statement knowing that it was false or with reckless disregard for the truth. The jury didn't specify which one it was. It said it was one of the other, and that was the finding. So in bankruptcy court, the bankruptcy judge would have to hold a hearing on Johnny's motion to saying that this conduct by Amber in her op-ed qualifies as willful and malicious injury. And the bankruptcy court would have to agree. There's been case law that I've looked at on there, and this is interpreted narrowly because the purpose of bankruptcy is to provide protection, not to exclude it. And there's cases like even a DUI injury doesn't qualify under this exception. So somebody driving drunk and harming somebody and then getting a judgment against them and saying, hey, I want exception from discharge. No, that doesn't qualify. You're looking at conduct that Amber knowingly understood that her conduct would cause harm and did it for the intention to cause harm. That may be true. I'm not saying it isn't true, but we do not have a finding from the Virginia jury on that point. It would have to be litigated in the bankruptcy court, and it's up to the bankruptcy court to determine that. My guess, and that's all it is the bankruptcy court's going to say defamation doesn't fall within this exception, and they're going to allow her bankruptcy protection. And once they're in there under Chapter 7 of the Bankruptcy Code, they can allow liquidation of the debt and saying, Amber, you own a house and you got a dog and you got, a car, and there's no way you can pay $10.35 million. We're going to reduce it down to zero or a small amount of money, or the $2 million. Maybe they'll do the offset in bankruptcy court and say, we'll call it even.
But they're not going to make her lose one of her, because she has multiple houses now, doesn't she? She just bought another one. Is there a point where bankruptcy can force you to actually have to liquidate, like you just said?
So it's hard if it's your personal residence. There are some homestead exclusions, like Florida has, I think, an unlimited one. California has a very limited homestead exclusion, meaning that your creditors cannot go after certain parts of your home equity. Of course, if you have lots of equity, maybe they can. It's very difficult, though, I can tell you, to try and collect a judgment against somebody's house. It's possible, very difficult to do. And when it gets down to it, she may dissipate her assets, meaning, kind of giving it to her sister or spending it down or putting it in trusts. And Johnny have to go chase her to the ends of the earth to collect this money. And he may do that. Or, he may just say, hey, I'm done fighting with this person and move forward. I think he would have been in that state of mind right after the verdict. But now that she's continually, coming out there and restating these same allegations against him, maybe he will try and collect it. But again, it's a judgment is a piece of paper that says money is owed. Converting that to cash and actually collecting it is a whole other action.
So you feel confident she's going to find the bond, she'll do it, that this appeal will last a couple years potentially, and this could get stretched out, and then Johnny's not going to get paid. The question is whether the Virginia court will allow Amber to get paid, is really the summary of where we're at this point.
Yeah, she's going to file an appeal. She's not going to post a bond to stay enforcement because she can't afford that. He maybe will try and collect the money from her. If the collection efforts become too intense, she may file for bankruptcy and she will certainly get some protection over there for a bit, if not complete protection. And I doubt that he'll end up paying her $2 million is kind of my sum up.
Well, I see other clearly she has a team that's figuring out. Someone's even saying she'll put the assets in her kid's trust, or there's probably things that her and her team can figure out to protect herself at this point now. That, it's going to be very unlikely that she ever has to pay the dime. So as frustrating as that is to hear, that's the reality here. Just real quick, Nick Knack was the first one up saying daily hello and thank you so much, Nick Knack. And Michael Clark just came in. Hope everyone is having a good day. Kelly D said, why would both appeal? Christopher pretty much laid that out because Johnny would need to appeal to, elongate it so he doesn't have to pay that $2 million right away. So that explains why. Living Dead Girl, I've sent you a link on an interview of today's judgment. Okay, I'll look for that in a second. And then Chill Chico, we got there. If anybody else has a question, I'm going to try and make sure I'm on top of chats today. So thanks for sending either Stream Elements or the link below, and we'll go there. So Christopher, this doesn't surprise you. It looks like the media, of course, tricked us a little bit in their headlines of potential settlements. If there was some sort of talk of settlement, they would have done that privately before today, correct?
Yeah, there can always be some settlement discussions, but I got to think that the only interest Johnny would have in that is to ensure that she's not going to continue talking about him and disparaging him. And so that would be difficult to try and arrange something like that because Amber's so invested in her story and wants to continue talking about it. So I don't see any really way of solving this one. And anything's possible, but it would be very difficult under these circumstances to bring any kind of resolution to this one.
Kim, any thoughts? I mean, let's just listen to a lot that we learned from Christopher here, but anything you want to add to this before I clip this portion, give people their update?
Not really. I think I would be curious. There's a lot of rumors about Amber potentially writing a tell-all book to attempt to get all of that money. With the defamation case and what's happened here, what are the implications of that? Could Johnny go after her again? How will that work?
He could. So one thing would be if he learns of who the publisher of that book is and that they're going to pay her money, he can try and lob onto that advance or royalties and say that he wants that money in satisfaction for the judgment that's owed. So that would be one thing he would try and do. In terms of suing her again, he may be able to do that. There is a non-disparagement clause in their 2016 divorce judgment that said neither of them would say anything negative about the other, even if it's true. Now, Johnny didn't sue for that. And it's interesting in what the Michael Jackson estate has done in that Leaving Neverland is that HBO had produced that kind of hit piece against him, and the estate sued HBO because they found this old contract that Michael Jackson had signed with HBO that included a non-disparagement clause. So the estate's going after HBO under breach of that agreement. Johnny didn't go in that direction for whatever reason. He sued for defamation, but at the book deal, he could potentially sue for her for breaching the non-disparagement. He could potentially sue her again for defamation. But you come now to the part where it's very difficult for him to do anything because she's now essentially judgment proof. She already has a judgment against her that exceeds her net worth. And so when somebody has nothing to lose, you really can't punish them effectively for speaking. I mean, another $10 million judgment would be worthless because he can't even collect the one that he has now. So that becomes very difficult. There's been some talk about an injunction, but here in the U.S., we have a First Amendment right to speak, and courts rarely have the authority to block somebody from speaking in advance. They can potentially punish that speech after it's occurred, but very rarely do what we call a prior restraint, is saying you cannot publish about. I mean, imagine if yourself or Andy were subject to an order by Amber. Like you can never utter Amber's name.
Let's start doing that for real.
Well, yeah, I mean, exactly. And if
she wants the attention, I don't want to say her name anymore.
Well, and you can see that if you had somebody like, we'll say Elon, I mean, world's richest person in the world. I mean, if he could access a court and saying, hey, I don't want people talking about me, and he certainly could hire every lawyer in the world. And if the court had the authority, you would see orders saying, like, you cannot talk about this guy. And we just don't do that in the U.S. because we have a right to free speech. So getting an order that you can't talk about somebody is extraordinarily rare. It could happen, like we see in my family law cases, if the conduct is harassing and was found to be harassing. The court can say, I'm going to block this person from committing further acts of those type of things. But very narrow. So very easy for people to tweet about, oh, get an injunction. We actually have, like constitutional restrictions against that.
Guys, I'm clipping this part in because I was going to clip it, but then Becca showed up. Becca was inside the courtroom today to offer us a little bit more insight. So Becca, before I wrapped up my trimmed version of today's long 4-hour stream, you were there and you were saying there was Elaine was having some fiery exchanges with Judge Penney. Is that what I'm hearing?
Yeah, Elaine wanted to prolong today. She did not want today to be the period at the end of the sentence, and the judge wasn't having it. And so there was some banter between Elaine and the judge. It was just going so fast, I couldn't even write it all down.
But clearly we've sensed this. Judge Penney's over Elaine, is done with it, has not seemed to enjoy, because you were there through some of the trial as well. There has been a lot of this sort of frustration, I feel like, even from the judge's perspective. Did you see that sort of carry over here, where she's like, it's over?
Absolutely. I mean, just to skip over onto the last sentence of my notes was, Elaine was trying to be polite and said, I hope Your Honor had a great vacation from this case. But the judge had kind of the same reaction as she did with the guy that was vaping.
Yes.
It was kind of a disbelief. I cannot believe you just said that. You know, she just she seemed very annoyed.
Was Ben there and Camille, or who was representing Johnny?
Ben and I believe Andrew.
Okay.
Yeah.
They were there, and then so did they have to say much, or was it pretty much cut and dry? Like, no, we're not doing anything.
Ben was fairly cut and dry. I think in my notes, pretty much everything that he said. I mean, it was very quick. He was basically saying, "I just want to sign off on today," and there was no injunctions or anything like that. So,
any other surprises that we should know about?
Trying to think. Was there, Tiff? Were there any surprises that you could think of? There was something that I was.
The judge just said that it's crystal clear.
Oh yeah, she just basically to Elaine was like, "This is crystal clear. I'm signing this. This is it."
I've spent 8 weeks on this.
She spent so many weeks on this case. She's done.
Did she say that?
Yeah, pretty much. I'm not verbatim, but yeah.
That's amazing. Good for her. I could totally relate. At this point, they had every opportunity. The law. It does seem like Judge Penney would have ruled for Johnny as well, is the vibe I get.
It's the vibe that I get as well. However, I do feel that there was complete non-bias on her part. So
yeah, I just think it was she wasn't falling for any of the spin they were trying to send out there. Well, interesting. All right, so she has a month now, I guess, to do an appeal. But it's interesting to hear that the scoop. Elaine was again trying to delay it. They want to delay this as long as possible to prolong this, which is very strange given that, they keep trying to spin it that Johnny's the one who's parlaying, right? That's been dragging her through the courts and everything else. But they're going to clearly...
The consensus for the delay is because Amber wants to appeal and she only has 30 days to raise the $10 million. And so I believe Elaine wanted to prolong this to give her time to pull that money together.
Ooh. And Judge Penney's like, Right. Not happening.
And then there was a back and forth. Let me see if I can find it in my notes. The back and forth between Elaine and the judge was post-trial motions. The judge says judgment will be final today. Elaine says, unless the judge amends. And then Judge Penney says, I'm absolutely not doing that today. It's not going in the order. I'm putting final on the order today. And then that's when Ben said, pardon me, may I speak? And then he stood up and agreed the final order should be today. And he says, I think something was different with Elaine's Exhibit A was different than theirs. And it was because Elaine said she couldn't figure out the technology. She had to copy and paste Exhibit A. So it was like she had some technical difficulties. So her document was different than their document. And so the judge ended up having to use Ben Chu's document because it was in the right, I don't know, PDF or whatever.
What a mess. Which again, just goes against all the other documents. Who knows what was real and the whole time, right?
Right. Yeah.
Insane.
And then another thing that was interesting was multiple filings that Elaine filed to the court in the last couple of weeks were filed sealed. And the judge was like, well, if you're appealing, nothing can be sealed. So I'm going to be unsealing everything.
Ooh.
So there are things that are going to trickle out on the Fairfax County website. Keep your eyes open because there are some sealed things that were filed that we will now have access to.
Oh, there you go.
I think that's probably, for me, that's what was like, oh, I wonder what those were, you know?
Yeah, I really love Judge Penney. I really feel like she wasn't taking any crap this case or from Amber's nonsense, and I applaud her for it. And not in a biased way, just like, again, they weren't very good.
No, I get it. Yeah.
So bravo. I appreciate that insight. Well, awesome. There we go. I'll make sure I added that to our video to make sure you guys get this exclusive.
I do want to add that the judgment there will be some redactions. Anything that's mentioning the foreman, the jury foreman, the name of the jury or the signature of the juror will be redacted for 1 year.
Interesting, but that doesn't stop them from talking. It just their identities.
Correct.
Right. Well, amazing. Yeah. Amazing. Anything else?
That's kind of it. You know, Ben and Elaine are very nice to each other, very cordial. I walked out with them. We took the elevator down. Elaine complimented my blouse. She's a different person when she's not in the courtroom, and I can see that she's trying to be a bulldog for her client, and I give her that. And but outside the courtroom, she's a really nice woman, and I do wish that the vitriol towards her people would just calm down, because she has a job to do, you know.
I mean, I agree. I lost a lot of respect when she was in that TV interviews. I don't know. I just feel like she didn't need to go there. I understand in the court, but on the TV,
I do have personal opinions about that as well. But of course, we're biased.
Yeah, it didn't feel well, as was she, and that she in the court of law I understand, but in the TV, but I guess it is all straight for the client and for the appeal. So one could argue it still is part of her job. But yeah, next time you see her, you should be like, blink if you don't like your client. I'm curious.
I really wanted to say something in the elevator. I want to be like, so you're here, you're alive, good. You know, like she survived this weeks and weeks of, I mean, technically years, because she went to the UK trial. But anyway, yeah, I feel for her. I have some empathy.
Hit the subscribe button, everybody here. Hit the bell as well. There it is. You're watching on screen. Smash that like button. Leave a comment down below. And stay tuned. We'll be back next week live. And I'll try and drop some videos for you if I can this weekend. Or I just might take the weekend off. Either way, love y'all. Stay tuned. Be excellent to each other. Bye.
Laters.
Bye, guys. Thank you, everybody.